Proposed NAR settlement, worst of all possible worlds. That was one of the leading headlines on Inman, which is one of the most reputable real estate news sites. And this is an opinion piece that was written by Tanya Monestier, who is a law professor, and talking about what she sees as issues ever since the NAR settlement that she wants for the courts to consider before they give the settlement final approval. So I want to dive into the points that she makes because they're really, really important for home buyers and consumers to consider. So that's what we're going to do this episode, is talk about what has the NAR settlement actually changed and what are the issues that still need to be resolved. But before we get there, little introduction. My name's Nick, the host of the DIY Homebuyer podcast. Super glad that you're here. My mission is to empower homebuyers to represent themselves without having to hire a costly buyer's agent the next time that you purchase a home. And the reasons for wanting to do that are multiple. One is just that you can save on average $15,000 or more in not having to pay buyer agent commissions or not having to have the seller pay that. You're able to leverage those funds in all kinds of other ways that will help you, benefit you. And then secondly, because I think that knowledge is power. And for far too long, there have been gatekeepers, whether that's the National Association of Realtors, brokerages, or individual realtors that have withheld information from consumers that have prevented them from being able to successfully represent themselves. And I think that the time for gatekeeping is done. So looking to make positive changes in the industry, trying to advocate for consumers and helping you to purchase a home, like I said, without having to hire a buyer's agent. And there's never been a better time to start a new model like what I'm doing here, because the spirit of the lawsuit against NAR and then the settlement and rules that came about as a result of it was to try and make the home buying process more fair and equitable and ideally more financially efficient. It's supposed to create pathways for unrepresented buyers to actually save money when they purchase a home. And this article that we're going to explore really just examines, okay, are the rules that went into effect on August 17th accomplishing their intended purpose, or are there other issues that we still need to consider? And spoiler alert, there are other issues. And that's exactly what we're going to get into here. So let's dive into the article. Tanya Monestier has become well known in the real estate industry for her criticism of new transaction forms. So real quick, those transaction forms refer to buyer broker services agreements, or just the agreements that buyer's agents now have to have their clients sign before they're allowed to show any homes. And these agreements outline what that buyer's agent will receive in terms of compensation and how they're going to be compensated. So they now have to disclose what they're getting compensated and how much the buyer is potentially on the hook for should they choose to work with that agent. So that agreement has to be in place according to these new rules before an agent is allowed to show a home. All right, back to the article. So she's been critical of these transaction forms created after the National Association of Realtors proposed settlement of multiple antitrust suits. Now, the University of Buffalo contracts law professor, so that's Tanya's role. She is a professor at University of Buffalo in contract law, so she knows what she's talking about. So she's taking a more active approach to the fate of the deal as a home seller objector to the settlement and the heaps of cash the plaintiff's attorneys stand to get. So she's got two things here. One, she thinks that the rules have been ineffective. They've not accomplished or solved the spirit of the original lawsuit, which is consumer protection. She doesn't believe that they have made a big enough difference. And then secondly, she's objecting to how much money the attorneys who represented the plaintiffs are getting paid. We'll get into both of those here. The article continues on. On Monday, October 28th, Monestier, who says she sold a home in Rhode Island in 2022 and therefore is a member of the seller class affected, filed an objection to the settlement in the U.S. District Court for the Western District of Missouri. The filing asks the court not to give the NAR deal final approval as it is scheduled fairness at its scheduled fairness hearing on November 26th in Kansas City, and to reject the plaintiff's attorney's request for some 33 not 33 $333 million in fees from the combined $1 billion settlements reached with NAR and other defendants. Okay, so she's saying, hey, court, do not approve this final settlement deal. It hasn't been effective, and these attorneys are making way too much money. $333 million. That's 33% of the final settlement. It's a lot. So Monestier's filing is comprehensive. It's a 136-page filing. But here's what it boils down to. Consumers are not getting anywhere near sufficient value from the settlement, either monetarily or through its required business practice changes, and it may actually leave them worse off. Let me say that again. Here's the number one issue that 136-page objection comes down to, is that consumers are not getting anywhere near sufficient value from the settlement. So we'll get into what does that mean? What value are consumers getting? And that is twofold, that it's not enough monetary value or through the required business practice changes, and that it may leave them worse off. So back to the headline of the title. This is a quote from Monestier, where she said, "The settlement is the worst of all possible worlds." Quoting her, "Under the pre-NAR settlement paradigm, the rules were clear, and confusion did not reign supreme. Sure, sellers paid inflated commissions, but the rules of the game were well established. The settlement agreement takes a tiny baby step toward decoupling, but in a way that is just an illusion. We basically just have the pre-NAR settlement system in place with a whole lot more paperwork, headaches, lies, chaos, and frustration." That is quite the accusation. Essentially, she is saying that nothing substantially has changed from the consumer's perspective, that brokerages and real estate brokers and agents have found workarounds to functionally make it so that real estate transactions operate the exact same way that they did before the NAR settlement. But now it's just a whole lot more confusing, and there's a lot more paperwork involved. And there's an interesting line in here where she said the settlement agreement takes a tiny baby step toward decoupling. That decoupling word is going to be important. We'll unpack that further. But really, that's, in my opinion, what needs to happen, where the idea behind decoupling is that sellers pay their agent, the listing agent, and that buyers pay their agent, the buyer's agent, and that sellers do not offer any sort of buyer's agent compensation. Now, it leaves the door open for sellers to make an additional concession to the buyer to help cover the cost of a buyer's agent if the buyer chooses to use one. But the idea of decoupling is making it so that sellers are not offering upfront compensation to a cooperating buyer's agent. Back to the article. Monestier is not just screaming into a vacuum. Her criticisms of the NAR settlement not only have the potential to affect court proceedings, but also influence the Department of Justice. In her filing, Monestier details her interactions with the DOJ, including a presentation she gave to about a dozen people at the federal agency on this topic, as well as a 41-page memo she provided the DOJ. The filing notes, much of what appeared in the memo to the DOJ is also contained in this objection. In the filing, Monestier stresses that how the settlement has been applied on the ground has made it, quote, an abject failure because, again, quote, it preserves the status quo of sellers paying both brokers and commissions remaining steady at 5 to 6%. So, again, she's just saying that, all right, since August 17th, nothing's really changed. The status quo has remained where the most typical way that real estate is sold is where sellers are paying both the listing agent and the buyer's agent, and that commissions haven't really dropped, that they've remained steadily between 5 and 6%. Quoting Monestier again, it says, industry participants are doing several interrelated things to perpetuate the system of seller-paid buyer-broker compensation. Refusing to take listings where the seller does not agree to compensate the buyer's broker, messaging to the seller that if they don't offer compensation, they won't get offers, and steering buyers away from properties that don't offer buyer-broker compensation. So those are three major issues, and these were all at the spirit of the heart of the lawsuit, the original lawsuit against NAR. So let's take each of these in turn. Refusing to take listings where the seller does not agree to compensate the buyer broker. So here's how that conversation goes. Listing agent meets with a seller, says, hey, I would be happy to list your house. They talk about the listing agreement, and the listing agent says, okay, for me to take this listing, you've got to pay me 3%, and then you've also got to pay the buyer's agent 3%. You need to offer that in terms of compensation. And if the seller says no, then the listing agent says, okay, well, then I'm not going to work with you. You'll have to find another agent. So that's an issue. Second is messaging to the seller that if they don't offer compensation, they won't get offers. So just basically applying this undue pressure upon sellers that just says, hey, if you want to sell your house, you have to offer significant compensation to a buyer's agent. Otherwise, people aren't going to buy your home. And so it creates this, it's essentially a scare tactic or a form of manipulation to make it so that sellers feel like they have to offer compensation. They don't really have a choice. And then finally, the third issue here is steering buyers away from properties that don't offer buyer broker compensation. And this one's a little bit more complex, but the idea here is that a buyer's agent will not show a property where there isn't a offer of buyer agent compensation, which means that home buyers miss out on what could potentially be the very best home for them because of this lack of compensation. And so that is a form of steering that is anti-competitive, violates antitrust rules, at least in the opinion of this attorney or law professor, Tanya Monestier. So back to the article here. While some brokers and agents think it's not a problem if buyers self-steer, that's in quotes, self-steer from properties where sellers aren't offering buyer agent compensation up front, Monestier argues that the result is that sellers feel compelled to preemptively offer that compensation and nothing changes. She goes on, this is a quote of Tanya. It says, that leads us right back to square one, with the seller covering the full cost of commissions. And according to some buyer's agents, sellers are covering the commissions post-NAR settlement in 99% of cases, and they're telling their clients that. So again, this is just nothing has changed. There's extra paperwork involved, but functionally, she's saying that, yep, we're just right back to where we used to be. And hopefully that self-steering makes sense. Like the difference here is that it used to be buyer's agents could filter properties in the MLS based upon the offer of compensation. And so they could choose not to show any homes where the offer was less than 3%. That's been removed from the MLS, but in the buyer broker services agreement, the buyer has an option to say, yeah, I don't want to see any homes where the seller's offering less than 3%. And so then the buyer's agent is able to leverage that. And they say, well, I'm not steering. My client doesn't want to see any homes that has a lower offer of compensation because they don't want to have to come out of pocket to compensate me. But the issue here is that that's highly manipulative because one, it leads to buyers missing out on what could potentially be the best homes for them. And two, it places, again, that undue pressure upon sellers to offer compensation when that should not be the case. So that's what she's arguing. The result, sellers feel compelled to preemptively offer compensation and nothing changes. The article continues. Under the NAR deal, the primary business practice changes that multiple listing services and brokers had to put in place were to remove offers of compensation from the MLS. So I just mentioned that, and to require buyer agents to have buyer agreements with compensation specified, signed before touring a home. So nothing new there. Quote, the goal of the settlement was laudable, Monestier writes. It was based on the premise that buyer brokers were using commission rates posted on the MLS to steer buyers to properties that provided higher levels of compensation. But those business practice changes only made sense on paper, according to Monestier, because sellers or their listing agents can still offer buy-side commissions in advance. This is the issue, offering these things in advance. The settlement continues to prop up the current system, she argues. And this is a really, really good point that she goes on to make here. Quote, the enforcer of this settlement is the defendant itself, end quote. So the NAR, National Association of Realtors, settled the case and said, basically admitted, essentially admitted wrongdoing. I guess not formally; they weren't found guilty, but that's sort of what settling implies. And so they came up with these new rules. But who is it that's enforcing the rules? Oh, it's the National Association of Realtors. And so Monestier goes on, she says, sort of like the fox guarding the henhouse, it will leave sellers still offering buyer broker commission in advance because they fear, and this is an issue when sellers fear that buyers will skip their house if they don't. It will leave buyers only seeking out properties where they know their buyer broker will be compensated by the seller. And especially for me and for our audience here, is that it will leave any potential unrepresented buyer out in the cold. If you don't play by the rules of the industry, you get shut out, and it will leave us in a worse position than we were before. And this has been a huge, huge issue for me. Something that I keep pushing on is that the goal of this whole NAR settlement was to make it so that buyers could save money either by negotiating the commission with their agent and trying to get as low of a commission percentage or fee or however they want to structure that as possible, or that home buyers could save significant money by learning how to represent themselves, which is the whole goal behind the DIY Homebuyer podcast and DIY Homebuyer Academy. Because if you don't have a buyer's agent, then you should save that 2 to 3% or whatever most buyer agents are charging, especially if the seller's not having to pay that, or if you're not having to come out of pocket for it. But what Monestier is observing is that with the way that these rules have been implemented and all of the workarounds that the industry has found, unrepresented buyers really don't find any advantage because these offers of compensation are negotiated up front. And there's still really no point in a buyer negotiating the compensation for their agent down if sellers are still offering 3%. Right? Like what's the buyer agent is, if they know that the standard offer of compensation from sellers in their area is 3%, they are going to be bold when they meet with potential clients in just saying that, hey, I charge 3%. That's what most sellers are willing to pay as it is. And so take it or leave it. And you see how it just takes all of the teeth out of the buyer's ability to really negotiate a better deal for themselves. So back to the article, she maintains that lawyers came up with the deal without realizing how it would actually play out. Quote, in the real world, the implementation of the settlement has been a disaster. It has not eliminated steering. It has not resulted in lower commissions. It has not shifted the obligation to buyers to pay their own agents. It has led to widespread confusion and the exploitation of consumers. It has not accounted for the psychology of buyers and sellers, and it did not anticipate the lengths to which the industry would go to ensure that the commission structure that has prevailed for decades stays firmly in place. That's why she says that this whole settlement and the rules are an abject failure, is because they don't actually work in the real world. These rules were all theoretical, what the lawyers came up with, but the actual implementation has not worked out for the advantage of the consumer as was hoped. Monestier details 7 workarounds that agents and brokers nationwide are using to breach the NAR agreement en masse, all of which boil down to tailoring what buyer brokers get to whatever a seller is preemptively offering. These include amending a buyer representation agreement so that the broker can get more compensation from a seller once the broker knows how much the seller is offering. Buyer brokers accepting bonuses from sellers above what was negotiated with the buyer, including a compensation range rather than a definitive amount in the buyer agreement, and using touring agreements in addition to buyer representation agreements, among other tactics. So, let's look at each one of those that are mentioned here and talk about how these are workarounds that breach the agreement. So, one is amending a buyer representation agreement so that the broker can get more compensation. This works in 2 ways. One is that the buyer's agents up front are just setting their commission percentage unbelievably high. So they're saying that, like, hey, we're going to agree to 5%. That's my going rate. But if the seller is offering less than that, then we can renegotiate and I will come down to what the seller is offering, so that way if the seller is offering 3%, the agent looks like a hero because they're willing to negotiate their fee down, but they're still getting the full amount that the seller is offering. The other way that this goes is that the buyer agent might say, hey, I'll do it for I'll sign the agreement for 0% or 1% or whatever it is. But then once we find the house for you and find out what the seller is offering, then we'll just revise the agreement to whatever it is that the seller wants to pay. So it essentially makes these agreements very loose and open, and allows for buyer agents to take full advantage of whatever a seller's offering to pay. The other issue is buyer brokers accepting bonuses from sellers above what was negotiated with the buyer. And this happens especially when a seller is like desperate to get an offer. They'll offer a $3,000 bonus to a buyer's agent. And this becomes an issue because, again, it's not something that's outlined in the buyer representation agreement. And it's essentially that bonus is really a bribe. It's really a seller saying, hey, I'll pay you $3,000 if you turn your client's attention toward my home versus any other homes that might be a good or even a better fit for your buyer. So it financially incentivizes a buyer's agent to do what's in the agent's best interest financially and personally, but blurs the lines as to what's in the best interest of the client. So that's another significant issue. And then mentioning the other workarounds of compensation range. So, I'll get compensated anywhere between 1.5% and 3.5% based upon what the seller is offering, rather than using the definitive amount in the buyer agreement. And then the touring agreements, these are new. And we should talk about these. I think we're going to get more into it as the article continues, but you're going to start hearing a lot more about touring agreements. And these are fraught with issues as well, because it essentially kicks the can on having to have the compensation discussion, which is the main thing that the original lawsuit wanted to enforce. So diving back into the article here, Regarding modifying buyer agreements upward, Monestier believes, though she acknowledges she is in the minority, that such modifications are not a workaround, but rather a breach. So, not just a workaround, but the full on breach of the NAR settlement. Quote, the modified bump up agreement would run roughshod over the settlement provision that the amount of compensation reflected must be objectively ascertainable and may not be open ended, e.g., buyer broker compensation shall be whatever amount the seller is offering to the buyer, Monestier writes. Quote, what a modification would allow, albeit indirectly, is the broker to collect whatever amount the seller is offering to the buyer. This could easily be accomplished by specifying a compensation rate of 0% to secure potential buyers who will be reluctant to enter into a buyer agreement that obligates them to pay any commission. The implicit understanding between the buyer and agent will be that a new agreement will be entered into after the seller's promised rate of compensation is known. So, this is not just a workaround, but an actual breach, because now we're setting buyers up to sign on with an agent with, again, back to that original language of like, hey, there's no strings attached and you're not going to pay me. The seller's going to pay me. So let's sign this agreement at 0% so that you feel good. Let's look at homes. And then once we find one that we like, we'll figure out what the seller's offering for compensation. We'll sign a new agreement together and we'll just put in whatever number that is that the seller is offering. And Monestier says that runs roughshod over the original spirit of the lawsuit. In the article, it says, regarding touring agreements in which buyers are not required to compensate their agent at all or very little in order to attend property showings, Monestier asserts that such agreements could easily be used to operate business as usual. Every realtor could enter into a 1-month touring agreement and keep renewing it, and then sign a formal buyer representation agreement when his or her client decided to proceed with an offer, she writes. Quote, functionally, this would be the exact same thing as the status quo where realtors proceeded without written agreements in place. All of this shows a concerted effort to allow buyer brokers to collect whatever the listing agent or seller is offering, something that is explicitly prohibited by the settlement, she adds. And this is so important because the idea is if a seller is offering 3%, but a buyer has an agreement with their agent for just 1%, well, what happens with that additional 2% discrepancy? And from the consumer's perspective and the perspective of the lawsuit, that 2% should either benefit the seller or the buyer. It shouldn't benefit the agents that are involved. They shouldn't receive additional compensation. They should be responsible for negotiating what it is that they're going to get paid. That should all be clear up front. And so if the seller's offering more than what a buyer negotiated with their agent, then great. That additional bit either makes the buyer's offer more attractive than somebody who's coming in with a buyer's agent that has a higher percentage, or it can benefit the buyer because the agent could offer that additional 2% as a credit to the buyer to make the house more affordable. So that's what the lawsuit was wanting. But these workarounds or direct breaches of the settlement rules are eliminating that possibility for buyers and sellers and making it so that agents are still maximizing the amount of compensation that could possibly be offered to them. So Monestier notes that her objection doesn't discuss outright willful breaches of the NAR deal, even though she anticipates such violations may be widespread. The reality is that many realtors will refuse to have a client sign a representation agreement prior to touring a property, she writes. In these cases, the realtor will likely backdate any buyer representation agreement and have his or her buyer sign the backdated agreement as part of the offer, Unless brokerages actively police their agents' practices, no one will be any the wiser to the practice. And again, it's just that whole the fox guarding the henhouse thing. Like you're asking brokerages and the NAR to police something that benefits them to let it slide. There's a conflict of interest there for sure. And then she gets into the what the lawyers are getting compensated. So continuing on, regarding the monetary amount the settlement classes can expect to receive, she points out that affected home sellers would recover perhaps $20 or $25, not even enough money to buy a pizza. This is supposed to compensate me for the $27,500 I paid that I shouldn't have had to pay, but for the defendant's alleged misconduct. Monestier emphasizes that the lion's share of the settlement fund would go to the law firms representing the plaintiffs, not the class members. Quote, billing at their normal rates, plaintiffs claim that the value of their work product is approximately $92 million, she writes. Quote, this includes fees for many attorneys billing at rates of $1,000 to $2,200 an hour. Plaintiffs' attorneys are seeking approximately $333 million in fees, plus $16 million in expenses. She says she found evidence that some plaintiffs' attorneys have misstated their billing rates or, more charitably, charged completely different rates to different clients during the same time period, and that granting the plaintiff's attorney any more than 10% to 15% of the settlement fund would be an unwarranted windfall. Quote, if this court chooses to approve the settlement in whole or in part, then I ask this court to disapprove the exorbitant request for attorney's fees, she writes. I don't think this court wants to be known as the one who provided a few dollars to class members and a private jet to each of those attorneys in the case. So clearly she feels passionate about how overcompensated the lawyers are in this case, which is kind of ironic that it's a case about agents being overcompensated. And one of the outcomes is that the attorneys themselves would be grossly overpaid for their work. The ironies of life. As a lawyer herself, Monestier lamented the impression that attorneys' request made on the general public. Quote, this gives the legal profession such a bad name, she said in a statement. The more I read about the attorneys' fees and looked into their billing rates, I felt really uncomfortable with the judge just rubber stamping the agreement. The more the attorneys take, the less the class members get. It's about the perception that this is lawyers driving litigation for lawyers, not to benefit consumers. She says she felt compelled to speak up about the settlement because at this point in the process, the plaintiffs and defendants are united in asking the court to approve the deal. Over $1 billion is at stake, Monestier writes, and neither party has an interest in rocking the boat. Defendants want to move forward without the constant fear of being bankrupted by future antitrust suits, and plaintiffs have over 300 million reasons to call this a win and move on. Unless someone speaks up, the court is likely to be convinced that this settlement is fair, reasonable, and adequate, she adds. But it is not. It simply reinforces the existing system of seller-paid inflated compensation while pretending to eliminate it. She asked the court for the ability to participate in the November 26th hearing over the phone or through Zoom, noting that the judge in the case, Stephen R. Bao, had recently required objectors to show up in person. Quote, this in-person requirement serves to stifle the voice of objectors, Monestier writes. No reasonable person would pay thousands of dollars out of pocket to come to a hearing for a settlement which, if approved, nets them a few dollars. So that is the conclusion to the article. And I wholeheartedly agree that the fee that the attorneys are looking to get in this case and what that comes at the expense of, which is the actual class members of this lawsuit, not that the attorneys would get $333 million collectively, but that would leave the class members to get $20 to $25. That feels pretty dodgy. And so I wholly agree that the court should not approve that. But I think that the points that she makes about how these settlement rules not accomplishing their intended effect is really compelling, and that the court really needs to consider that, and that there needs to be further revisions of these rules, and that they actually need to be strengthened. I do not think that any seller should be offering a set commission amount upfront to a buyer's agent. I just don't see how that's beneficial to the consumer at all. And really, it's not an offer of compensation. It's like I said earlier, it is a bribe, because the thought is that, okay, if I offer a higher compensation to a buyer's agent than my neighbors or the other available homes that would be comparable, then the buyer's agents are going to be financially incentivized to push their clients toward my house versus other potential homes. And it's that financially incentivizing buyer's agents to do something that's in their best interest versus what's in the best interest of their client that is really the major like consumer issue. And hopefully that conflict of interest is really clear to everybody listening here, that a buyer is hiring a buyer's agent to look out for the buyer's best interests financially, as well as to help them find the very best possible home. But you muddy those waters a ton when you start to say that a buyer's agent can get paid different amounts based upon what a seller is offering on different homes. And so that's why it was so important with the lawsuit that that number, what the buyer's agent is going to be compensated, is made very clear, very objective upfront, and that there's no way for that to change. So that is a major ongoing issue. And really the only way that I think that gets solved is by sellers stopping offering any sort of compensation upfront. Always leave it TBD. And any listing agent that's telling their sellers that they need to offer a set amount upfront, they're not actually looking out for the best interest of their clients. They might make it sound like they are, but they're actually just trying to protect the industry in the way that things have always been done. They're looking out for their paycheck. They're looking out for the next time that they work as a buyer's agent. They want to receive a set amount of compensation. These realtors do not want to have to negotiate. And so I know that change is hard, but this has to change. And of course, this whole episode has really focused on the lawsuit, and there's been a sort of implicit like this is most valuable, right? If you're working with a buyer's agent or if you're selling a home, to be aware of these things. But hopefully, it creates the category for folks to just see why learning to represent yourself is so incredibly valuable. Because with the way that the system is currently structured, I just don't think that buyers can fully trust their buyer's agent to look out for their best interests. There's just too many misalignments within the incentive structure that I think it's far better for buyers to learn how to look out for themselves and to be able to capitalize on this potential savings where they're able to negotiate the fact that they don't have a buyer's agent, that you don't have to account for that $15,000, $20,000, or in the case of this attorney Tanya, she paid $27,500 to a buyer's agent when she sold her home in 2022. If you can remove that fee from the transaction, that's going to benefit you as a buyer. Like, that's just plain simple math. Like, I don't care how it's framed, whether it's seller paid compensation, like that money has to be accounted for somewhere. And if you're able to purchase a home without having an additional middle person that's receiving a percentage of the sale, there is a way to leverage that to your advantage, whether that's making your offer more attractive or whether that is saving you money. So I do think it's important for buyers to learn how to represent themselves, to not be dependent upon these buyer agents, to work directly with listing agents or sellers. I've got a ton of resources and material on that. You can listen to previous podcast episodes, or I talk about how to deal directly with listing agents, negotiation strategies. You can also join the free school community, skool.com/DIY Homebuyer. Homebuyer. And there you can engage with other DIY home buyers, find a full collection of resources that I've created, as well as I've got a free course that just covers all of the essentials of how to buy a home as a self-represented buyer. If you got questions, I'd love to engage with you. So you can shoot me an email, hello@DIYHomebuyerAcademy.com, and I will get back to you as quickly as I can. Leave comments on here. And then because just really, this is like part consumer advocacy, part just wanting to create the category for folks about the legitimacy of self-representation, I need your help to get that word out. And the best way that you can do that is by subscribing to the channel here, subscribing to the show, leaving a comment, a like, a review, and more than anything, if you found something helpful in here, sharing it, whether that's posting it on your social media account or sending it directly to a friend that you know is considering buying a home. The goal is to create value, to make informed home buyers believe that educated consumers are the best kind of consumers. But for this to be effective and for this to be totally, maximally worthwhile, I need your help with getting the word out. So very, very glad that you're here. Thanks for coming along. We'll be back soon.